Ladies and gentlemen, it is 2:10 and we're going to go ahead and get started. Mark and Tom, I'd like to start by thanking our sponsor of this session, the U.S. Chamber of Commerce. You're here for Court Watch. And I also want to introduce myself. My name is Anna Daly, and my two esteemed colleagues up here. We've been doing this for a couple of years now, Williams and Tom Herney. So what we're going to do with this session
till you came up.
is we picked out what we think are the 5 top cases that the West Virginia Supreme Court issued decisions on this past year. And we're going to do that in the first 30 minutes. And then in our second 30 minutes, we're going to hear from the 4 legislators that truly got 2 pieces of legislation through, drove it through this year, and that is the Intermediate Court of Appeals bill and the COVID liability bill. So without further ado, we're going to go ahead and start our, I'm getting feedback. Is that my, okay, thank you.
All right.
Boy, I went through those fast, didn't I? All righty. The first one I'm going to take, and that's AmerisourceBergen versus Moats. So this is opioid litigation. There are 80 plaintiffs. They are hospitals, state and local communities that have sued drug manufacturers, and the drug manufacturers wanted to bring in pharmacists and others. It's at the multi-litigation panel, and there Judge Moats wanted to and asked the parties if they would agree to allow the equitable claims, and there are 2 sets of claims running up on this. There's the equitable claims and then the claims at common law, and there are several of those. But the judge, like Judge Faber did, had asked that the parties agree to try the equitable claims first before the court rather than send that to the jury first. And the defendants wouldn't do that in that case, which makes a lot of sense, but they did do it in the Judge Faber matter. So one of the reasons that I believe from reading the decision that they didn't want to have the court try it is that if they try it in front of the court, then it makes it a lot more difficult when you send the common law claims to a jury, and by that point you've got a jury that's already presumably found, they're going to find liability if the court has found liability. The defendants wanted the opportunity to try their case in front of a jury. The other thing is that some of the defendants wanted to, we call it the empty chair defense, but wanted to use our comparative liability statute to identify defendants not there at trial who bear some responsibility under comparative negligence. And Judge Moats, or the panel, had said no. So these 2 issues went up on a writ to the Supreme Court, and out of our 5 justices, we have 4 different written opinions. Justice Walker wrote the majority for the court, and she said that 1, these claims ought to be tried to a jury, and 2, that the empty chair defense was something that could be decided at some point once you had gotten through discovery. Am I right about that? I'm thinking, because I wasn't in the case. Both of these gentlemen, Mark is in the case, and I think Tom Herney's firm is in the case. So in any event, Hutchinson wrote his own opinion and thanked and recommended, applauded the analysis that Justice Walker did, but thought that the court shouldn't have handled it, that it was probably still premature for the court to be making some of the decisions. But Wooten, let me say that Jenkins wrote the opinion for Armistead and himself. And I'm going to make sure I'm getting that right as well. And then, and they concurred with everything, although they also said that they thought that the court should have allowed the empty chair defense right away. And then Wooten wrote an opinion, and he was highly critical of the counsel, and I will say that Hutchinson was pretty critical too of counsel for bringing cases up to the Supreme Court on writs that he felt were premature. It shouldn't be done at that stage, and he felt like it was a nuisance. Reading the decision is probably the best way, in my opinion, to learn the predilections of our West Virginia Supreme Court justices and which way they're likely to go in the future. If you want to predict for your client what you think our Supreme Court will do, this decision and reading all of the written opinions is an excellent guidepost for that. And I will say I think Justice Walker has shown herself to be a real centrist on the court. You guys want to add anything to that?
Yeah, let me add one issue about the fact that there were 4 opinions from out of the 5 justices. We're seeing an increasing number of cases decided where there's this additional opinions, whether dissents or concurrences. And I think, frankly, that's a good thing, because to the extent that justices have a difference of opinion or want to explain in more detail a specific issue, they're taking advantage of that in these other opinions. And I think that gives all of us as practitioners guidance. The interesting thing about the process and how it's different now than it was a few years ago is they're releasing all of these opinions together. And Chief Justice Jenkins has explained in some speeches that he's done around the state and some press statements as well, that that's an intentional decision on the part of the court to make sure that all of the justices see all of the opinions that are going out before the majority opinion is issued and any dissents or concurrences. That way, and as a result, you'll see something like you see in United States Supreme Court opinions, where a majority opinion might refer in the opinion to the dissent because they've seen it before it gets issued. And again, that's also something that I think is favorable for us as practitioners to give us additional guidance on what these opinions mean.
And just the other thing on appellate stuff, for all you appellate nerds out in the crowd, these are cases that go up on extraordinary writs. I mean, this isn't a final decision that was appealed. This is a case where you challenge what the circuit judge did and assert basically there's a 5-factor test, but basically there was a clear error of law. And so if you look particularly at the Hutchison separate opinion, the Wooten separate opinion, they express this frustration about the use of writs as opposed to letting the parties litigate the case and come up on a final order. And you see a little bit of that frustration. So the question looking forward, and you'll see, I think 3 out of our 5 cases that we picked for our ESPN top 5, and we didn't get our music, but are writ proceedings. And so it's interesting looking forward as to whether you're going to see as many writs issued, because the court is expressing some frustration with that.
You want to handle the Hope case
for
us?
So this is an interesting case. And what the court said was that the discovery rule applies to cases brought by the Attorney General seeking civil penalties under the State Consumer Protection Act. The Consumer Protection Act says you can't award penalties for any behavior more than 4 years before the filing of the suit. The manufacturers in the case, by the way, the suit was about respirators. The state brought a suit saying you manufactured and distributed defective respirators and it costs the state money in paying out health claims and other things, and we want to recover against the manufacturers. The other part of the claim was for civil penalties, and that was really what the court focused on, can you toll the statute of limitations? And West Virginia law is pretty clear that the statutes of limitation don't start running until you knew or reasonably should have known, or if you can show that the defendant fraudulently concealed. So this was a little bit of a stretch. Now, I do want to point out, this is a 5-0 decision. And there was a concurring opinion by Jenkins and Armstead. And they said, we concur in applying this court-made doctrine to extend the statute of limitations in this case, but you shouldn't assume we're going to do it all the time. So they just kind of gave a little warning. But that was really the point. There's a couple other issues in that case, but the big one is that statutory, the extension of time of the 4-year statute.
Yeah, the interesting backstory on this case is it was filed in 2003 by former Attorney General McGraw and has been sitting for 15 was sitting for 15 years without it really any activity. And it's an attempt to recover, as Tom said, the cost of black lung benefits that were paid by the state as a result of miners that supposedly contracted black lung because they were using defective respirators. That's the theory. But the case has been sitting in Lincoln County for 15 years, and finally, even after Attorney General McGraw left office, the Morrissey Attorney General's office continued to push it, and then finally decided to try to spur it on by carving out a section of the case and said to Judge Hoke, let's go forward with this case on a limited issue, which really brought up this whole question of statute of limitations. It's now been remanded back, and we'll see what happens. But that case also was on an extraordinary writ like the first one.
Yep. All right, number 3 case. So this is the shoplifter case at Walmart up in Parkersburg. So this guy named Least gets caught outside Walmart by security, and they bring him back into the store to wait for the police. And Least busts loose, runs down the aisle in Walmart, runs into Ms. Ancrum's shopping cart, takes the cart and Ms. Ancrum down with it. She's severely injured, and the case goes through discovery, goes to trial, $16.9 million verdict for this lady that got knocked over when the shoplifter ran into her shopping cart. So pretty big verdict, probably the largest verdict we've seen in several years in West Virginia. So here's what happened. First of all, on appeal, Walmart said, look, we can't have a duty to customers if shoplifters go running off and run into them. That shouldn't extend to us. And the fact that he committed a criminal act ought to interrupt the causation. That's what we call an intervening cause. Supreme Court said, based on the record, they found no error in a finding of duty and a finding that there was enough evidence to let the jury decide proximate cause. So liability damage verdict is upheld at $16.9 million. The next question is, they looked at the 2005 version of our joint and several liability statute, which has been, by the way, amended in 2015. Senator Trump will know. And said under that statute, the jury apportioned 30% to Walmart and 70% to the criminal shoplifter. The plaintiff cross-appealed and said, you can't do that. That's a third-party defendant. Because the plaintiff didn't sue the shoplifter because he doesn't have any money, right? Walmart third-partied the shoplifter. They turned around and sued him, brought him in the case. Court held under the statute, third-party defendants are included on the verdict form. And the significance of that holding is that under the statute, if you were 30% or less in terms of the fault apportioned to you by the jury, you only paid your share. So Walmart paid 30% of a $16.9 million verdict, and the rest was just simply not paid. Unless the shoplifter came into some money. I don't know that. So the other thing they did is they gave prejudgment interest on the medical bills, which is sort of normal. Walmart challenged that and said, look, the insurance company paid those bills. This lady didn't pay them. She shouldn't get prejudgment interest. And the court held that under the statute that was appropriate. So I think the key takeaway to this case is probably the idea that the foreseeable conduct of this criminal shoplifter could result in liability to Walmart. That third-party defendants under the old statute counted, and you get prejudgment interest. So pretty interesting case. You had Jenkins and Armstead wrote separate opinions, dissenting in part, concurring in part, and we can talk about those a little bit later when we have more time. But that's the Walmart versus Ancrum.
Let me add one thing on that. I was a little surprised by this holding for this reason. This court has dealt with the issue of when you have a crime that is committed, whether there could be tort liability for the foreseeable consequences when you're not the actor, you're not the criminal. And in the past, previously, they actually found that there could be tort liability, and the court received a lot of criticism over that. And I believe the legislature passed a law that says that you can't do that now in certain circumstances. But to find that there was no error in finding a duty implies that I'm not sure that there was a de novo review of that issue as you normally would have. Because frankly, finding a duty in the case where a retailer is responsible for the unforeseeable acts of someone engaged in a criminal act doesn't make a lot of sense to me. I would think that probably the appropriate response to that would be that there is no duty in those circumstances if it's unforeseeable. Now, if Walmart had a rash of shoplifters and that they routinely ran them through the store and engaged in that sort of thing that would have resulted in harm to potential customers, that might be a different story, but that's not the fact pattern that was here. So under the circumstances, I was a little surprised by this decision.
Yeah, and they also there's a statute that offers some liability protection against shoplifters, but as the court pointed out, it wasn't the shoplifter who got hurt. So I think Mark's right. I mean, it's a little bit of a head scratcher in terms of predicting liability in the event of criminal behavior by third parties. So we'll probably see more development in the law in that area.
All right, on to number 2. In our annual recitation of class action litigation at the Supreme Court. And we're going to talk about probably one of the more significant class action decisions that has come out in the last 20 years. And that is State ex rel Cernaic versus Bedell. I think I'm probably pronouncing Cernaic wrong, right? Zach, close? Okay. This arose from the Parkersburg fire when you had the warehouse fire a few years ago, if you all remember that. And there were a bunch of cases that were filed out of that. Most of those ended up in federal court and were dismissed by Judge Johnston, but there were a couple that, because of the way they were pled, stayed in state court, and they ended up in front of Judge Bedell in Harrison County because all the Wood County judges had to recuse themselves. And they were filed as a class action, and as is often the case, because of some decisions that occurred in the past that are very liberal in terms of how class certification is interpreted, Judge Bedell certified that class, and I'm referring specifically to the Reslin decision, which was 2001, 2004, something like that, which was a really liberal standard, a very low bar for class certification. And if any of you have been in class actions, you know that once a case gets certified, it usually settles because there's way too much risk associated with it. It also will settle for a lot more money. Our court has been hearing a lot of cases involving class actions over the last few years, and this is another one in that group of cases where they have reviewed the issue of a class being certified. So it goes up, once again, on a writ. And that's the process by which you evaluate or seek appellate review of a class certification decision. Judge Bedell had certified the class, and the defendants challenged it. And if you've heard our talks about class actions in the past, you know that we have made the point that West Virginia had such a liberal standard for class certification that it was dramatically different than in the federal system. And that we thought that it would be better if there was one standard for class certification, both in the federal system and the state system, and that would require our Supreme Court of Appeals to start applying federal standards for the criteria that goes into determining whether or not a class should be certified. They did that in 2019 in the WVU Hospital versus Gajot case on a couple of the issues. This is the next step. And dealing with the question of predominance, which is, do the class issues predominate over everything else? Judge Bedell said yes. The Court of Appeals here said no, and said that predominance requires a much more rigorous review. And essentially that's what we're seeing in a lot of these class action cases that go up. They go up, they get reversed and get sent back down because the review that's being done at the trial court level isn't sufficiently rigorous enough. They're not looking at enough. They're basically just rubber stamping the orders that are handed to them by the plaintiff's lawyers. Now, as it turns out, After this decision was rendered, it went back to Judge Bedell. He once again certified the class, notwithstanding the language in this opinion, which is very restrictive, which finds that the Resland decision should not be followed in these cases. And now the Cernaik 2 is actually before the court. Another a writ has been filed in that case by the defendants. So it's gone back up now for an additional review. So we're going to see more of this class certification question coming up over time until the trial courts start applying the law as directed by the Supreme Court of Appeals.
Yeah, and I think the next thing to see, I mean, number one, the court has expressly said we are going to look to federal decisions for guidance, which is something they said they would not do in Resland. The other interesting thing to me is, as the court follows some of the U.S. Supreme Court cases, Walmart versus Dukes and others, now that they've got the cases going back up like Cernaik, the question is now with a thorough order or a thorough examination, is the court going to defer to the circuit judge on class certification, or are they going to apply these principles and say, no, you shouldn't have certified a class? You know, we read these cases as not, you know, I have a good friend who's a plaintiff's lawyer says, hey, we just need to get better orders. And I don't read the cases like that. I read the cases as you got to do the analysis, and it has to actually answer the questions. And so I think we ought to be watching Cernaik very carefully to see what the court does. And to the extent there's other cases, the Gajot case, the case I'm involved in that may or may not be going back up to the court, but I'd be paying attention to what the court does kind of in the, not to talk about the next wave when we have the Delta variant, but the next wave of these cases in the court, and just see what they do with them.
The last case is a personal jurisdiction case, and this was out of the business court. You'll recall the legislature formed a special court to hear basically business-to-business disputes. And this was a dispute between a West Virginia-based laboratory services company against a West Virginia-based healthcare reimbursement company, Healthmark, and the lab company actually brought in every Blue Cross Blue Shield entity from around the country, 54 of them, including Blue Cross Blue Shield of South Dakota and Blue Cross Blue Shield of Nevada, et cetera. Brought them in, and the question was, can you even sue those people in West Virginia? I mean, they don't do business here. They do business in other states. And it came down to a question of, well, is the fact that they put information on a website which is accessible in West Virginia, is that sufficient? And the business court held that it was. That the fact that they have a contract with the main Blue Cross entity, but not with Highmark, whether that was sufficient, and the business court said yes, it was. So you had this interesting, really intellectually challenging question of, can a West Virginia court exercise authority over an entity that doesn't actually sell products in West Virginia, doesn't do anything here, doesn't own property, doesn't have employees. The only way that the holders of their policies could somehow be involved is if they were vacationing in West Virginia or passing through and had a claim that ended up going to a local hospital. Other than that, they're not going to have any reason to be here. The United States Supreme Court has been struggling with this issue on several occasions over the last few years and has greatly restricted the ability of courts to exercise this personal jurisdiction, saying that you have to have a very close connection before you can do that, essentially, to exercise specific jurisdiction. That the cause of action has to arise from the contacts. That's the test. A couple of years ago, we had a decision out of West Virginia that was a little more liberal, that was written by Justice Davis, that arguably is inconsistent with the Supreme Court's decisions, so it was unclear how this would play out. What we had here was the Supreme Court reversed that decision of the business court and said, no, you can't exercise personal jurisdiction, and brought our personal jurisdiction jurisprudence in line with the United States Supreme Court and what they've been saying about the same issue.
So we're going to cover very quickly the stats and trends, and also we want to mention judicial hellholes. We're going to need to cover this quickly.
Okay.
Okay?
The only issue on statistics is that we do these every year, but largely the amount of work being done by the court is consistent with what they've done in the past, with the exception of the impeachment year where you would expect that to be lower. They have been as productive as before. What you're going to see with the intermediate court is that's going to change because a lot more cases that normally don't go up to this court are going to go to the Intermediate Court of Appeals because they're changing the way that certain cases are reviewed. So there's actually going to be more work for the appellate courts as a result of this change.
So we always comment on the ATRA report of judicial hellholes. West Virginia is not a judicial hellhole for the third or fourth year in a row. And again, this is based on surveys they do of their members. It's not really a statistical or scientific survey. But this year they didn't like three things. They aren't crazy about the composition of the court after the last election. They're not crazy about the Attorney General bringing civil lawsuits and hiring personal counsel. And they really didn't like the 3M case that we talked about. And so we're kind of down in the commentary just says they're a little worried about West Virginia. So be that as it may.
Yeah, and the only thing that I would add on the Attorney General issue is to the extent that the Attorney General is bringing actions under the Consumer Credit Protection Act, the Attorney General's authority in that respect is fairly broad and different than a private entity who would bring a claim under the same statute. And the opioid claims that they filed are under the CCPA, the 3M, the same thing. They're part of the Attorney General's enumerated authority under that act. So to the extent that there are legislators that may be wanting to look at something that might be appropriate for review, that might be something they'd want to look at.
Let's go on to the order issued yesterday from our Chief Justice.
Yeah, the last thing is that Chief Justice Jenkins yesterday issued an order, and you're going to hear more about this from the panel that's coming up next, appointing stakeholders from a myriad of entities to act as an advisory panel for the Intermediate Court of Appeals. I think this is a great development. It gives people and entities like the State Bar and the legislature and judges an opportunity to have their opinion heard on what goes into the rules for the application of the Intermediate Court of Appeals. We're building a separate level of Court of Appeals from the ground up. And by appointing this advisory committee, I think this is a great step in the right direction, and it's an effort on the court's part to try to make sure that everybody who has a stakeholder in this issue can be heard.
So I want to thank our two panelists for doing this again. Also, if you go to the Chamber website or if you go to the book, the agenda book, 4 pages, depending on how you count your pages from the back, is a QR code. We've got a lot more case summaries there, and I want to thank all the people who helped put that together, and you will see that on the website. At this point, we want